This is plaintiff's redacted motion to compel defendant to answer deposition questions filed under Seal 1. The plaintiff is Virginia Giuffre by and through her undersigned counsel. She hereby files this motion to compel defendant Ghislaine Maxwell to answer deposition questions. During her recent deposition, defendant refused to answer numerous questions about allegedly adult sexual activity related to Jeffrey Epstein. Because this activity is highly relevant to this case, defendant should be ordered to answer questions about it. As the court is aware, this defamation case involves Ms. Giuffre's assertions that she and other females were recruited by defendant to be sexually abused by Jeffrey Epstein under the guise of being massage therapists. See complaint DE1 at legal jargon. Giuffre described Maxwell's role as one of the main women who Epstein used to procure underage girls for sexual activities and a primary co-conspirator and participant in his sexual abuse and sex trafficking scheme. In response to these assertions, defendant has made the sweeping claim that Ms. Giuffre's assertions are entirely false and entirely untrue. Defendant has labeled her entire deposition transcript as confidential at this time. Counsel for the parties conferred at the deposition regarding answering questions. Case 115 CV 07433 LAP, document 143, filed 5/5/16, page 1 of 10. Yet, during her deposition, defendant refused to answer any questions that she construed as having something to do with consensual adult sex. Defense counsel supported that position that, frankly, it's none of your business, and I instruct the witness not to answer. See Declaration of Sigrid S. Macaulay at Exhibit 1. TR of Maxwell Depot, April 22nd, 2016 at 21. The result was that at a number of points throughout her deposition, defendant refused to answer questions about subjects integral to this lawsuit, including questions about what the alleged massage therapists were doing at Jeffrey Epstein's house and the sexual nature of those massages. For example, defendant refused to answer questions about whether she had given Jeffrey Epstein a massage. Question: have you ever given Jeffrey Epstein a massage? Mr. Pagluica. Object to the form foundation. Object to the form foundation. And I'm going to instruct you not to answer that question. I don't have any problem with you asking questions about what the subject matter of this lawsuit is, which would be, as you've termed it, sexual trafficking of Miss Roberts. To the extent you are asking for information relating to any consensual adult interaction between my client and Mr. Epstein, I'm going to instruct her not to answer because it's not part of this litigation and it is personal, confidential information not subject to this deposition. Miss Macaulay, you can instruct her not to answer, that is your right, but I will bring her back for another deposition because it is part of the subject matter of this litigation, so she should be answering these questions. This is civil litigation, deposition, and she should be responsible for answering these questions. Mr. Pagluca, I disagree, and you understand the bounds that I put on it. Miss Macaulay, no, I don't. I will continue to ask my questions, and you can continue to make your objections. Question: did you ever participate from the time period of 1992 to 2009? Did you ever participate in a massage with Jeffrey Epstein and another female? Mr. Paluca, objection, do not answer that question. Again, to the extent you are asking for some sort of illegal activity as you've construed in case 115 CV 07433 LAP document 143, filed 5516, page 2 of 10. See, I'm just saying that that's at the bottom of the page. It was really hard to read this because I had to copy and paste it. So just bear with me. It's embarrassing, but bear with me. I'm not using my wits right now because it sounded like that was a part of it, but apparently it wasn't. So I'm going to go back. Objection, do not answer that question. Again, to the extent you are asking for some sort of illegal activity as you've construed in connection with this case, I don't have any problem with you asking that question. To the extent these questions involve consensual acts between adults, frankly, they're none of your business, and I will instruct the witness not to answer. Miss McCauley, this case involves sexual trafficking, sexual abuse. Questions about her having interactions with other females is relevant to this case. She needs to answer these questions. Mr. Paluca, I am instructing her not to answer. Miss McCauley, then we will be back here again. Defendant's participation in massages with Epstein is a central part of this case. Ms. Giuffre has explained that during her first sexual encounter with Jeffrey Epstein, it was defendant who provided instruction on how to do it and how to turn the massage into a sexual event. Obviously, proof that defendant had previously massaged Epstein include massages with sexual component would provide important corroboration for Ms. Giuffre's testimony at the trial. And proof that defendant was involved in massages will further help prove that statements to the press that Virginia's allegations were obvious lies was itself an obvious lie. As another example, defendant refused to answer questions about her knowledge that Joanna Schoberg was hired to work for Epstein and provided massages. In the police report, Joanna admitted that Maxwell recruited her to work for Epstein. Yet during defendant's deposition, she refused to answer questions regarding Joanna Schoberg. Question: do you know what tasks Joanna was hired to performance? Answer: she was tasked to answer telephones. Question: did you ever ask her to rub Jeffrey's feet? Answer: I believe that I have read that, but I don't have any memory of it. Question: did you ever tell Joanna that she would get extra money if she provided Jeffrey massages? Answer: I was always happy to give career advice to people, and I think that becoming somebody in the healthcare profession, either exercise instructor or nutritionist or professional massage therapist, is an excellent job opportunity. Hourly wages are around $7, $8, and $9, and as a professional healthcare provider, you can earn somewhere between, as we have established, $100 to $200, and to be able to travel and have a job that pays, that is a wonderful job opportunity. So in the context of advising people for opportunities for work, it is possible that I would have said that she should explore that as an option. Question: did you tell her she would get extra money if she massaged Jeffrey? Answer: I'm just saying, I cannot recall the exact conversation. I give career advice, and I have done that. Question: did you ever have Joanna massage you? Answer: I did. I did. I don't know why I'm losing the accent. I did. Question: how many times? Answer: I don't recall how many times. Question: was there sex involved? Answer: no. It's ... What else am I supposed to interpret that as? Did you ever have sexual contact with Joanna? Mr. Pagluka, whatever your name is. Object to the form and foundation. You need to give me an opportunity to get in between these questions. In between the questions. Anything that involves consensual sex on your part, I'm instructing you not to answer. Question. Did you ever have... Now she has an accent. Did you ever have sexual contact with Joanna? Answer. Mr. Pagluka? Again, she is an adult. Question. I'm asking you, did you ever have sexual contact with Joanna? Sexual content. I'm asking you, did you ever have sexual contact with Joanna? I'm not meaning to make light of this, by the way. I'm just fucking up. Answer. I've just been instructed not to answer. Question. On what basis? Answer. You have to ask my lawyer. This fucking lawyer. Okay. I'm trying to keep it unbiased here, but this is really annoying. The bottom of the page thing again. Here again, this information is critical to the case. Among other things, these questions are designed to show a modus operandi for Epstein and Maxwell, specifically how they recruited for a non-sexual massage, then converted the massage into sexual activities. One last illustration comes from defendant's refusal to answer about her knowledge of Epstein's sexual interests during massages. Question. Does Giuffre like to have his nipples pinched during sexual encounters? Mr. Pagluka. Objection to form and foundation. Answer. I'm not referring to any advice on my counsel. I'm not talking about any adult sexual things when I was with him. Question. When Giuffre would have a massage, would he request that the masseuse pinch his nipples while he was having a massage? Answer. I'm not talking about anything with consensual adult situation. While Epstein himself might also provide answers to these questions, it appears likely that he will assert his Fifth Amendment privilege regarding his sexual activities. Accordingly, Ms. Giuffre must pursue questioning, I don't know why I have an accent anymore, of Maxwell to obtain information on this subject. Here again, information about Epstein's sexual idiosyncrasies will provide important corroboration to Ms. Giuffre's testimony that she had sexual interactions of an identical nature with Epstein. These refusals are not an isolated instance. Instead, similar refusals to answer questions occurred repeatedly throughout the deposition. Court should compel defendant to answer all these questions. In addition to the specific points made above, the big picture here reveals how vital such discovery is. At the core of Ms. Giuffre's allegations is the allegation that defendant lured her into a sexual situation with the offer of a job making money as a massage therapist, that Epstein always habitually tried to turn massages into sex. That was his modus operandi and plan all along. And that Maxwell recruited other females for an ostensibly proper position, such as therapeutic masseuse, with knowledge that the intent was for that person would be pressured to provide sexual gratification to Epstein. As a result, Epstein's use of massages for sexual purposes is a central part of this case, and defendant's role in those massages, and knowledge of the purposes of those massages is a critical piece of evidence showing her state of mind when she attacked Ms. Giuffre's assertions as entirely untrue. Ms. Giuffre intends to prove at trial that defendant knew full well the sexual purpose for which she was recruiting females, including underage females like Ms. Giuffre. Ms. Giuffre is entitled to explore defendant's knowledge of the sexual activities that took place under the guise of massages. Otherwise, defendant will be able to portray to the jury an inaccurate picture of what was happening at Epstein's house, was nothing more than run-of-the-mill massage therapy. Question: did the pay for massage therapists vary on what sexual acts they performed? Answer: no, it varied depending on how much time. Some massage therapists charge more and some charge less. Defendant's refusal to answer questions about alleged adult consensual sex also blocks Ms. Giuffre from seeking a legitimate discovery in this case. By refusing to answer questions about her and Epstein's sexual activities with alleged adults, defendant is essentially given the ability to refuse to answer any sexual question she does not wish to answer. Defendant simply has to deem the question as involving consensual adult sex, and no need be given. The result is to leave Ms. Giuffre with no way of exploring the identity of these alleged adults, the ages of these alleged adults, and indeed whether they were adults at all. This allows defendant to claim that she is unaware of any sexual activity involving underage females, because she claims the only sexual activity she was aware involved adults. The court should compel Ms. Maxwell to answer all questions about her knowledge relating to sexual activities with Epstein and other females while at Epstein's various homes. Under the federal rules, when a party refuses to answer a question during a deposition, the questioning party may subsequently move to compel disclosure of the testimony that it sought. The court must determine the propriety of the deponent's objection to answering the questions and can order the deponent to provide improperly withheld answers during a continued deposition. Internal citations omitted. Of course, the party objecting to discovery must carry the burden of providing the validity of its objections, particularly in the light of the broad and liberal construction afforded the federal discovery rules. For purposes of a deposition, the information sought need not to be admissible at the trial if the discovery appears reasonably calculated to lead to the discovery of admissible evidence. Chen Oster versus Goldman Sachs and Company, 293 FRD 557561, SDNY 2013. Defendant cannot carry her burden of showing that the questions asked are not reasonably calculated to lead to the discovery of admissible evidence. This is a case in which sexual activities lie at the heart of the issues in dispute. As a result, it is hardly surprising to find that discovery pertains to alleged adult sexual activities, and questions about such subjects are entirely proper. C.E.G. Condit versus Dunn, 225 FRD 100-113, SDNY 2004. In defamation case, plaintiff is hereby ordered to answer questions regarding his sexual relationships insofar as they are relevant to the defense of substantial truth, mitigation of damages, or impeachment of plaintiff. Weber versus Multimedia Entertainment Incorporated, number 97 CIV 0682, PKL THK 1997 WL 729039 at 3, SDNY November 24th, 1997. While discovery is not unlimited and may not unnecessarily intrude into private matters, in the instant case inquiry into private matters is clearly relevant to the instant case inquiry into private matters is clearly relevant to the subject matter of the suit. Accordingly, plaintiff Misty Weber shall respond to defendant's interrogatories concerning her concerning her sexual partners. Generally speaking, instructions from attorneys to their clients not to answer questions at a deposition should be limited to issues regarding privilege. Morales v. Zondo Incorporated, 204 FRD 5054 SDMY 2001. In this case, defense counsel ranged far beyond the normal parameters of objections and sought to decide for himself what issues were relevant. That was improper, and the court should order a resumption of the defendant's deposition so that she can answer questions about her knowledge of sexual activity relating to Jeffrey Epstein. Conclusion: defendant should be ordered to sit for a follow-up deposition and directed to answer questions regarding her knowledge of alleged adult sexual activities. I think that's it. Let me see. See if I missed anything. I don't think I did. I think that's about it. Let's see. Yep, that's about right. I got that right. I guessed that last part because it wasn't all the way finished. Anyway, that is from... That's from the new batch of unsealed documents. This is a document from May 5th, 2016, from the defamation case regarding with plaintiff Virginia Giuffre versus Ghislaine Maxwell. And it was called Plaintiff's Redacted Motion to compel defendant to answer deposition questions filed under seal. So yeah, it's unredacted now, because I just read it. But I'm not the only one who's read it, so it's whatever. And I have other things to unredact. And thank you so much for listening. Bye-bye.